Good morning. Hello, good morning, and welcome. To borrow a phrase for some of our older viewers there, welcome to what is our first and touch wood, not our last webinar, first in a series of webinars really aimed at sharing relevant, topical, informative advice on HR issues that are affecting businesses. I'm Steve. I'm from Index eBusiness, which is one part of the partnership here today. Certainly going to hand over to Heidi very shortly from Reality HR. I thought it would be useful to just share a little bit about us at Index eBusiness from our side of things. So we're a software development company, and over 15, 20 years or so now, our software has evolved from being absence management software for small, medium-sized businesses, all the way up to what it is today, which is a all-encompassing HR software application. So yes, it includes absence management. There's employee contact directories in there. There's expenses and documentation. There's report writing tools, and most recently the employee feedback and engagement module built into the system too. And whilst we are at Index eBusiness, we're experts in software development, even if we say so ourselves. We're also very good at helping our customers align their HR processes with our HR planner software. So we're able to fine tune and customize the software so that the two things work very well together. But we know as software developers, really we can only offer anecdotal advice around HR issues, of which we have plenty and happy to share. But as HR becomes more important to businesses, we want to be able to do more than that. So hence teaming up with the good people at Reality HR, who really do have a tremendous amount of knowledge and experience around legal and policy perspective of HR. So just to finish up, don't worry, I'm not going to be showing you the software today. I know that's not what you've come here for. But if it's okay, I will drop each of you an individual email over the next day or two, just with a bit more information about our software. Maybe there's something we can do to help as well. And with that, Heidi, if you are ready, let me remove the spotlight from me. There we go. So enjoy the session, and I will catch you another time. Cheerio.
Thanks so much, Steve. So we are ready to go with Preventing Sexual Harassment, Understanding the New Worker Protection Act. So as Steve says, Reality HR, we are a HR consultancy. We're actually based in Basingstoke, so just outside London. We have been in business for 20 years, celebrating our 20th anniversary this year. We've got 23 CIPD qualified team members, so a massive amount of HR knowledge and background amongst the team. Personally, I've been in HR for longer than I'm going to tell you, but I've been head of learning and development here at Reality HR for a number of years now. And so my role is to bring that HR knowledge, that HR expertise from the team, and hopefully share it with you guys in an interesting and engaging way. So that's my plan for this morning. What are we going to cover? We are going to cover an overview of the New Worker Protection Act and what that means, how that changes the existing legislation. We'll just talk briefly about defining sexual harassment and the various forms and some examples of what would constitute sexual harassment. It's a slightly different category to our previous understanding of what harassment meant under the Equality Act. We will talk to you, I will talk to you this morning about what types of activities as businesses you could be considering now to prevent sexual harassment in your workplace, possibly over and above what you've currently been doing. And I'll talk to you about why that's going to be so important. The word prevent is absolutely the key for us to understand this morning. So then I'll give you some actions, immediate actions you can go away and do over the summer in advance of this legislation becoming live later in the autumn. So before I continue, I would just ask if everyone's happy to mute themselves for now. You'll have seen the session is being recorded. We're going to share this for you to forward on to anyone else, but also for anyone who couldn't make it today that had registered. So being on mute is great because then we don't get any background noise from anybody. But I'm very, very happy to take any questions. So during the session, please feel free to put any questions into the chat, and I'll try and keep an eye on that chat and answer them as we go if possible. But then I hopefully will have a few minutes left at the end for anyone to unmute and just come on and ask any questions if you've got any. It's so nice to have an actual conversation if anyone's brave enough to ask their question out loud. So type them in the chat. I'll keep an eye as we go. Hopefully everyone's seeing the slides clearly, but again, just let me know in the chat if there's any issues with sound or picture quality or anything at all, and we will do our best to fix that as we go. Right, where are we at the moment? So in August 2024, we are currently in the position where harassment is unlawful under the Equality Act 2010. Now, we've had 14 years of this existing legislation that defined harassment as one of a type of unlawful behaviours. Others include discrimination, indirect discrimination, victimisation. So harassment is just one part of the unlawful behaviour outlined under the Equality Act. And that set out that harassment is unwanted conduct related to a protected characteristic that has the effect of violating a person's dignity or creating an environment that is hostile, intimidating, degrading or offensive. So that harassment definition has been around a long time, and I'm sure you will all be aware of what that means and the slight difference between bullying and harassment in the eyes of the law. So employers have a duty of care currently to protect workers from all forms of discrimination, harassment and victimisation. Employers can be found currently vicariously liable for harassment in the workplace if they have not taken reasonable steps to prevent it. And employers can currently defend a harassment claim by showing that they've taken reasonable steps from preventing that, to prevent the harassment, but also actually you can have a defence at the moment if you are able to show that you stopped harassment happening once you became aware of it. There is no legal definition at the moment of what should happen, what employers should be doing both to prevent or stop. And it's down to each individual employment tribunal to look at the facts of each case and decide whether an employer took reasonable action either to prevent harassment happening or to stop it once they became aware of it. So that's the current legal position. But what is changing? Well, from October 2024, the Worker Protection Act is an amendment to the existing Equality Act. So the amendment says that from October, employers now have to take reasonable steps to prevent sexual harassment. Now, the wording at the moment is just around sexual harassment, not around the other types or the other protected characteristics. But watch this space. The legal advisors we've been talking to are anticipating that sexual harassment is just the first step, and we're likely to see this grow and cover off some of the other protected characteristics as well in the future. Of course, with the new Labour government in power, they have got a very, very wide-ranging suite of policies that laws they're looking to change around employment. So we don't quite know yet what's going to happen, but really it is a case of watch this space. We do know that this sexual harassment piece, the duty to prevent sexual harassment, is absolutely set to become law in October of this year. So even though we've got all these other things bubbling away, we really do need to make sure that we're doing everything we can as employers right now on this sexual harassment piece, because we know that this is something we're absolutely set is happening. So from October, a tribunal will have the power to uplift any compensation paid to an employee in a sexual harassment case if you as an employer can't evidence that you took reasonable steps to prevent that happening. The original wording went through was all reasonable steps. That got slightly watered down by the House of Lords to just now say reasonable steps. We don't currently have a full definition of what those reasonable steps are. And actually, we're not ever anticipating having a full list. It's not going to be a checklist that suits every business, because the entire purpose of this piece of legislation is about you as employers bespoking your reasonable steps to your business. Your actions that you take have to be commensurate with the size of business, the type of business, the industry you're in, the type of employees you have, your location. All of those things are going to feed into what reasonable steps you should have taken. But the key point for all of us as employers, no matter how big or small our companies, whether you employ one person or 1,000 people, employers must show that they have been proactive in preventing sexual harassment. That's the crux of what's changing in October. So that last bullet point on my slide there is the absolute kind of crux of what we're talking about today. So what does that mean for us all? Well, we need to be able to clearly demonstrate what we have done to prevent sexual harassment occurring. And what we're anticipating, and in fact, we've already had indications from tribunals, even before this has become live legislation, is that many, many organisations will not have robust enough policies, practices to defend a claim, to show that you've made reasonable steps. So we are expecting tribunal cases to continue and really look in much more detail about what we did to prevent. Some of the tribunals have already been doing that, as I say, even before this legislation has become live. So we are really anticipating tribunals looking at what you've done. Was it enough? What else could you have done? And what else should you have done? And these are the key words that the tribunals are talking about. So let's just be really clear on what we mean by sexual harassment. I've already talked about harassment in general, being unwanted conduct that violates a person's dignity, etc. In relation to a protected characteristic. I'm not going to test any of you because, you know, that would be a bit unfair, but there are 9 protected characteristics. So harassment at the moment, the general term harassment can be any of that unwanted behaviour that relates to any of those 9 protected characteristics. And I'm not going to list all 9 off the top of my head either. But hopefully, if you're not sure on what those 9 are, you can just go in a quick Google, will tell you the protected characteristics. Now, this new piece of legislation that defines sexual harassment is slightly outside of that. So this is defined, this is the definition of sexual harassment. So when a person engages, again, we've got unwanted conduct, but unwanted conduct of a sexual nature that has the purpose or effect of doing all of those same things as our previous harassment definition. But what we do need to recognise here is that sexual harassment is a different offence to harassment related to someone's sex. Okay, so this is adding an additional claim that employees can make against someone who is engaging in unwanted behaviour against them. So really important that we understand that harassment can be by someone of the same or different sex as the victim. It can be a one-off or a repeated behaviour. So a one-off will be sexual harassment if it's severe enough, or it can be repeated kind of ongoing drip, drip, drip behaviour. It might be behaviour that's happened before and that has been accepted in the past, but has now become unwanted. And this is where we're going to, I think, as employers, we're struggling with that whole piece around culture and banter and behaviour that's always happened. Just because someone was happy with that behaviour in the past does not mean they always have to accept that continuing. So we may have found that someone's view changes, and that could be because of their individual circumstances, and it may be because they become aware that actually society is changing and it's now not politically correct to say that, and maybe they think, oh, actually now's the time I'm going to speak up. So we have to be mindful of the fact that if someone does raise a concern with us, just because they've accepted that type of behaviour in the past does not guarantee that they should continue to accept it. It doesn't matter if the conduct is acceptable to others or it's typical of that workplace. If someone finds it unwanted, hostile, degrading, humiliating, then that is harassment. if it doesn't need to be, the other point to just be really clear about with harassment is that it doesn't need to be directed at the victim or the person that raises the concern. It can be behaviour that's witnessed or overheard in a workplace. So if you have a two people engaging in sexual chatting, sexual joking, that they might both be quite happy with, but I sit at my desk here and I can hear it, then that is potentially right for me. That's enough for me to then be able to make a complaint or raise a concern that there is sexual harassment happening. If they're talking about topics that I find humiliating, degrading, or offensive, then that has created that environment of sexual harassment on me. So the other thing just to say at this point is that sexual harassment does happen and happens regularly in workplaces. There was a TUC poll back in May 2023, poll of over 1,000 women in UK workplaces, found that 3 in 5 women say they've experienced sexual harassment, bullying, or verbal abuse at work. 3 in 5 women last year. So this is current data, and this is a big issue. So we can see that as employers, we might be thinking, well, that doesn't happen here, that doesn't happen in my workplace. But if 3 in 5 female workers say it's happened to them, then we can be pretty sure it's likely to be happening in the majority of workplaces that we're in touch with. It isn't just against women. So my first point a minute ago was that harassment can be by someone of the same or different sex. Harassment can also be against someone of any sex. It's not just about protecting women, it's about protecting everybody from sexual harassment in the workplace. So hopefully all that's clear. I am keeping an eye on the chat, as I say, so if you've got any questions as we go, feel free to chuck them in, but still got lots to cover. So hopefully if you've got questions in your mind, I might well get to them in the next 15 minutes or so. Right, so let's have a look at some workplace examples. What constitutes sexual harassment? Well, comments or jokes of a sexual nature, displaying sexually graphic pictures, posters or photos. I'm not sure if any workplaces still have page 3 up on the wall or calendars with naked women, which is something that certainly was commonplace when I started in my career. Not quite so commonplace anymore, but be mindful that those sorts of things can fall under this heading of sexual harassment. There's a whole list on the screen here. I'm not going to read them out. You're all perfectly capable of reading those examples. But it's very, very wide ranging. So it is not just what might spring to mind when we think of sexual harassment might just be 1 or 2 of these, but actually look how wide ranging the definitions of sexual harassment are. So wide-ranging, all sorts of different behaviours. Sorry, I paused for a moment there because I saw a question which I'm going to come back to and answer in a second. So let's look at some real live examples. These are things that ACAS are using as live examples, and any of you that work in the HR field will have come across some of these, I'm sure. So I've already mentioned calendars. Screensavers are probably the more 2024 version of those. I don't know how many of us still have paper in our offices, but a screensaver with a topless woman. That could create an offensive environment for other workers. And that goes towards answering the question. So the question that's come into the chat says, could you please explain a bit more about how a party not directly involved can come under the definition? Well, this is a good example of that. So if my colleague who happens to sit next to me has a screensaver of a topless woman, for example, that they're very happy with, but I have to see it every time I walk past that desk, that's not necessarily directed at me, but if it makes me feel that environment is hostile, degrading, offensive or intimidating, then that's where I've become sexually harassed and can make that complaint that I've had sexual harassment. The rest of the examples on this slide pretty much are where behaviour is directed at someone. Oh no, look, the number 1, 2, 3, 4, the fourth bullet point here answers that exact same question as well, Simran. So hopefully that really helps explain that. So a man overhears a female colleague being subjected to sexually abusive language. So he wasn't being sexually abused himself. The language wasn't directed at him, but the culture, the environment that he has to work in makes him feel violated. His dignity has been violated, he's offended, humiliated or degraded. So even if the female colleague didn't complain, he has the right to complain because that environment is unacceptable to him. Now, hopefully, as soon as he raised his complaint, the employer would recognise, the manager would recognise that was that sexually abusive language to the female employee was also unacceptable, and would prevent it, to make sure both the female colleague themselves and anyone else in that environment are then protected going forwards. That would be an example of how we currently behave. When we hear it happening, we expect our managers to stop it from reoccurring. Remember that the difference with this new piece of legislation is that going forward, we should be doing everything we can to prevent that happening in the first place. And I'm going to go into in a moment of what types of activities we might be able to do to implement to prevent that type of behaviour happening in the first place. So there is further guidance coming from the Equality and Human Rights Commission, which is referenced on the bottom of my slide here. At the moment, these are the some of the examples they give. They've open consultation on some of these activities, and we're expecting full guidance from them in September. We aren't expecting there to be much change to what we cover today. But of course, we will keep you up to date. If there is change to any of the suggestions I make today, if there's additions that the I nearly got my letters, my acronym in the order there. I was going to say EHRC, but that's the order. So if there is anything that the EHRC add to our suggestions, we will come back and let you know. We'll keep you updated. Christine, I'm going to come back to that question at the end, if that's okay. I've just seen another question come into the chat, which should be something that's going to take a little while for us to bottom out, and we will come back and I'll answer that one separately. So what do we need to do as employers, as managers, as leaders in organisations, as HR professionals? Well, we need to understand what is the current state of play in our workplaces. So how many allegations of sexual harassment have you had in your workplace over the last year or two? You may have records. You may have records of grievances. That's going to give you a really good starting position. Where are you at right now? Maybe you haven't had any formal grievances raised. Maybe you haven't had any formal allegations of sexual harassment made in the last 12 to 24 months, in which case fantastic. But don't assume that just because you haven't had anything raised doesn't mean it hasn't been happening. If we look back to that TUC data that says 3 in 5 female employees felt that they'd been sexually harassed, we can think it's probably happening under the radar, that maybe it just hasn't been raised formally. So we need to consider, how are we going to find out, has there been anything that hasn't been raised? And you may want to consider running an anonymous survey, maybe not just as a standalone question, have you been sexually harassed, but maybe if you've got engagement surveys or employee surveys coming up, it could be a question to add into it. And I would strongly recommend that, actually. If you've got surveys coming, why not ask this question? Have you experienced or witnessed harassment in the last 12 months? Look at your exit interview data. Are there any indications from any of your exit interviews that there might have been some bullying or harassment that wasn't necessarily raised at the time? Are there pockets, are there areas or risk areas in the business? Maybe some of your data indicates people that work in one department have a concern, whereas the rest of the organisation don't raise concerns. Why is that particular area different? What makes that a risk? And currently look at what you how you deal with allegations. What do you do? Who resolves them? Who investigates them? Have you taken strong disciplinary action against anyone who's had an allegation against them or found an allegation to be with basis? What are your outcomes of your disciplinaries? Have you done investigations and then the investigating officer has kind of concluded that, oh, it was just banter, it was just joking, because that's a risk area for you. So look at your current workplace, look at what is existing at the moment, all of those questions there. What is the state of play in your organisation right now, before this legislation becomes live? Because actually that's going to be a really useful point for defence if a sexual harassment claim comes in the future, to say, well, we did this piece of investigative work. This is where our benchmark was. This is where we were in August 2024. These are the things we put into place. And then ideally you want to be able to track, obviously by next August, the following year, that you're having less allegations, less people in the staff survey saying they've witnessed or been victim to harassment. You want to have less reference to harassment in your exit interviews. And if you can evidence that the actions you're taking are reducing any of those allegations, then that's a really, really powerful position to be in. Both obviously for the legal defence, but also morally. I mean, this is all I'm talking here about what you need to do as employers for a legal position. But actually, let's remember at the end of the day, if we can prevent any type of harassment, sexual or otherwise, then actually we're creating a much happier, healthier, and more psychologically safe environment for our employees, which is going to help, obviously, all of our retention and our attraction and our employer reputation. Which leads me, like I knew it was coming, leads me nicely onto my next slide. Are the leaders in your organisation committed to this initiative? Are the leaders bought in? Do they know that? Have they heard this kind of webinar? Have they read anything about this? Do they even know that this sexual harassment legislation is coming? What are their thoughts towards inclusion strategies? Do you have a program already about inclusion, about creating an inclusive, psychologically safe environment? And if so, is it enough? And do you need to add more? So where are your leaders' heads at the moment? Do they know that in a tribunal, if a tribunal finds that you didn't prevent sexual harassment, your probably ex-employee at that point is going to be entitled to 25% more than they would have been had they won a normal harassment tribunal. Now, remember that awards in employment tribunals for discrimination and harassment are uncapped. So the largest award last year, in the last financial year, was £1.7 million of damages to an individual for injury to feelings. Imagine uplifting that by 25% because we hadn't done enough to prevent harassment in the first place. So the direct costs of grievances and tribunals can be phenomenal, but also the indirect costs. I've already just mentioned this. On the flip side, if you have a cultural environment where there are a number of allegations and grievances that aren't raised, that aren't dealt with well, you are going to have poor employer reputation. You are going to be unable to attract and retain your talented staff. Other people are going to feel disengaged, and we know that disengaged staff have poorer performance, are less productive, and have higher absences than those who are engaged. So are our leaders committed to making this work? Have we got a zero tolerance approach in the organisation, and do we actually mean it? This is a really important point. We come across, I mean, at the moment we work with about 180 different clients of all different sizes based across the entire UK, some with global arms as well. And every one of those, pretty much without fail, has a policy that says we will not tolerate harassment or bullying in our workplace. But just having it written on your policy is not going to be enough. It currently isn't enough, but it's going to be even more important that we think about this going forward because of this potential 25% uplift. So do we actually put our money where our mouth is? If we say we will allow zero tolerance, do we actually act on every single allegation that's raised? Do we do thorough investigations, or do we allow them to be brushed off? I have heard on a number of occasions in my time in HR, I've heard managers respond to allegations of bullying and harassment with, stop being so sensitive. They're just joking. Man up, grow up. Just join the joking. It's just banter. I've heard all of those responses from managers, and I hope that that's not something that you guys are thinking, oh, yeah, gosh, that's what we do, or I've heard that happen. So if that is something that's happening, and you've got a manager or leader in your organisation that doesn't take this seriously, now's the time to be starting that conversation about why this stuff really matters. Okay, so let's make sure we know what we're going to do. What steps can we take that we can start with right now, that we can work on over the coming months to prevent sexual harassment? Some of these will already be in existence in your organisation, but it's time for reviewing, making sure they're robust enough. So review and update all of your policies that relate to bullying, harassment. Insert a clause about sexual harassment specifically, or indeed a whole new policy. Either is fine, as long as you are covering off this reference to the new Worker Protection Act, you are covering off the reference to preventing sexual harassment. Update your policies. That has to be a given. We have to have that. That's the very, very first thing. But on its own, it's not going to be anywhere near enough. So we need to make sure we're following through with all of these other, or the most applicable of these other actions. Check whether you have a robust system for reporting issues. Now, your current grievance policy will probably reference how people raise a concern, how they report an issue. And it will probably say something along the lines of, talk to your line manager, unless your line manager is the person who you're making the accusation against, in which case talk to another manager or the HR team. Perfect. In bigger organisations, we expect the EHRC are going to be looking for the ability to raise concerns anonymously, as well as your standard reference in your grievance policy. Now, that won't be available to everybody, certainly not going to work in a small organisation where there's only 4 of you. You're not going to be able to make that anonymous reporting system, but do consider it. Do look at whether it might work for you. Make sure that the guidance for employees about how to raise a concern is really clear and has been shared. So once you've updated your staff policy and you've updated anything that's changing, make sure you reshare that and that you've got evidence that's been shared with everybody, so everyone knows how to find your handbook, where to find the policies. Okay, so on that point, there's been a couple of questions come into the chat there. So how can we deal with anonymously raised concerns? Yeah, great question, and very, very difficult to do so. But I think that we have to recognise that an anonymously raised concern is as valid as a concern raised with someone's name. They will presumably have named a perpetrator and given some example of when things may or may not have happened, so some allegations of what they've been unhappy about, and we would then have to do some investigation. We might have to interview anyone that was named as a witness. We would have to raise the concern with the person. It's very difficult because historically, my personal advice, and in fact most of my HR colleagues I know, is that it's not impossible to deal with an anonymous claim, because actually, how do you go to someone and say, oh, someone's told us that you've done this or alleged that you've done this, but we can't tell you who it was? It's a very difficult position to be in. But what we have to recognise is that the Equality and Human Rights Commission are referencing anonymous complaints, so we have to deal with them as much as we can. I do know of organisations that have an email address where people can send anonymous concerns in, or anonymous suggestions even. So there are ways that can happen. And Vicky, the next question was, what do I mean by bigger organisations? We don't have specific guidance on that yet. We are expecting hoping that the EHRC guidance that comes in September might give some sort of guidance about what they mean about bigger organisations. We don't know the answer to that yet. If you're 20 people, it's going to be very nigh on impossible to keep this anonymous. If you're 100 or more, then maybe it's more likely, more possible, but we haven't got a specific answer to that question yet. One of the things that all the lawyers that I speak to on these kind of topics say is make a contemporaneous note of why you did something. So if as part of your planning you decide that it's not possible to have an anonymous system because we're an organisation of only 50 people or only 20 people, and it would be obvious really who was raising the concern, then if you've considered that and made a decision that you're not going to put in an anonymous system, then make a note of it. The lawyers always say notes made at the time of the decision carry weight and help your memory. None of us are going to remember in 3 years' time when we get to a tribunal. Well, fingers crossed that's not happening, but should it happen, in 3 years' time we're in a tribunal, we are not going to remember all of these things that we thought through at the time. So one of the steps you could take here is to download our checklist, which is a questionnaire for you to help you with your planning, which I'm going to reference to at the end and I'll give you the link to. And actually make notes on there to say, we considered an anonymous system, but we decided not to because X, Y, Z. Then you've got that reference point. You've got evidence that you looked into it, you considered whether it was applicable to your organisation, and you decided yes or no based on the evidence at the time. So then we need to be considering our managers, our line managers, those that are going to investigate and manage any allegations. Have we got clear guidelines for them, and have we trained them on how to do that? Have we trained them in how to do an investigation? I mean, this isn't just for sexual harassment, this is across the board. Do our managers know how to do that? But in particular, on the sexual harassment piece, do they know how to take a concern seriously? Are they bought into the fact that this is we can't brush these things off? We can't just say, oh, stop being so sensitive. Oh, it was just a joke. Do they know that? Have we got evidence that we ran bespoke, tailored, targeted training for our managers, that we talked to them about this before they had to then investigate? Have we got evidence that we trained them in how to do investigations? Do we have, I don't know, policies, templates, sorry, to help them do that so that all of our allegations are investigated in a consistent manner? Have we got a template that shows how we're going to present any findings? So all of those things are going to be helpful. Obviously helpful to do proper investigations, which is the first thing that needs to happen, but secondly going to be our defence. Have we then, number 5, gone out to our staff to tell them about behaviours at work, unacceptable behaviours in the workplace? Have we told them what we as an organisation expect from them in terms of their values, their conduct, their behaviour? Have we told them what's unacceptable? Have we shared open spaces for them to debate it? Have we used, and this is another recommendation from the EHRC, is that we need to make sure that all new joiners have this information as part of their standard induction, and that might well include casual workers and agency staff. But everybody should be going through some sort of bespoke training on a regular interval. And again, I don't have an answer to what the appropriate interval is, but I can tell you that in a recent judgment from an employment tribunal, it was ruled that training that was 2 years old was stale and out of date. So take from that what you will. Do you think 2 years is an appropriate interval for your organisation to refresh that training, or would 12 months, every 12 months be better? Again, it will be down to your organisation to decide and keep a record of why you made your decision. It might not be that you need full face-to-face training for every single employee every single 12 months. It might be that you do some face-to-face training to launch this new policies now, to brief everyone on the new policies, and then in 12 months' time you roll out a short online e-learning session for people. And then in the following 12 months, you do a face-to-face update. And then the 12 months later, maybe you have some focus groups or discussion groups. It doesn't have to be the same every time, but having something at regular intervals is what the guidance recommends. And are you keeping regular employee data? So are you able to stay aware of what's happening throughout your organisation? Some of you will do regular employee surveys, some of you won't at the moment, but if you are doing them, then add in this question, as I say, about harassment. Have you been witness or subject to harassment? If you don't currently do surveys, it might be something to consider. And the same point with exit interviews. If you don't currently do exit interviews for those leaving the organisation, this may well be something to consider. Both surveys and exit interviews have intrinsic value for the organisation, not just around preventing sexual harassment, but actually they will also build into your defence should you have a sexual harassment claim. So there was a lot there. I've just talked at you for 42 minutes so far. In summary, really, what I would say is that there are some immediate things that you can do, and we will share, as I said, the slides, the recording, so that you've got that immediate steps to take. But the very first thing is to review your policy and make sure your policy, your procedures, what's in writing is up to date, and then do that review of what's actually happening in practice. And then thinking about training as we come into the autumn, briefing for your staff, absolute training for your line managers. I can't see any way you're going to be able to, any of us are going to defend a claim in a tribunal if we haven't got those policies written and training rolled out to the right audiences. There are lots of other things as well, but those are going to be, I believe, the fundamental things that are going to be your defence. Now, just before Steve comes back on and closes us off, I've got one question to answer. How can you defend? So we had this question in the chat. How can you defend if two colleagues are having a private conversation, but a third overhears it and is offended by it and raises it as they felt humiliated, even though they should not have been listening to the conversation? And that's a great question. That relates back to this whole point that harassment is not just it can be to someone who overhears, it can be to a third party who wasn't involved, it wasn't aimed at them, but they've overheard and become offended. And I think in this example, I would be talking to the two people that were having the private conversation about what's acceptable, non-acceptable behaviours, conduct, conversations to have in a workplace. But I would also be talking to the individual who's raised the concern about that, yes, of course, you're going to take action on making sure that doesn't happen, but also very gently reminding them that private conversations should be private. But actually, if there was somewhere they could be overheard, then those two colleagues that were having that private conversation, they should have been mindful of their environment. Maybe if they were overheard, then they need to be aware of that, you know, if they left the door open in an office or they were on a Teams call and they had their headphones on, but they were speaking out loud in an open or plan office, whatever it was, they were overheard. And that's actually what this comes down to, is that they were overheard. And we all need to be mindful that anyone could be walking behind our desks or next to us. That could be other colleagues, it could be clients, it could be customers, it could be suppliers. We all need to be mindful of our audience at all times, even if it's not the audience we're aiming directly at. So yeah, tricky situation, but that would be my response to that one. And my very last point is that we have a couple of activities coming up. So we have a face-to-face event for anyone who's able to get to Basingstoke. We're going to be partnering up with Phillips Law and Basingstoke and Dean Borough Council in September, on the 25th of September, to cover some of what we've covered today, but a wider piece about what is happening in employment legislation. So what are the new Labour government doing? We have a on-demand webinar available on our website that you can listen back to, which is another partner of ours, GK Strategy, who really talks about the election results and what is likely to come from this new Labour government. And then the point I mentioned a minute ago, this checklist to aid your thinking about how to prepare. And actually the checklist itself is editable. You can make your notes on it, and that's going to be a great foundation for you to keep to show why you decided to take or not take action at this time. Again, that will be available on our website. We'll share obviously all these links. And my only final point is to say thank you to Steve for inviting me along to talk to you guys. As you can tell, I love talking, and I love particularly talking about employment law. So it's great to be given an audience. So Steve, thank you very much for having me today.
No, not at all. I think you've covered everything. Excellent. Some really useful points there. I'm sure that everyone can take away from. And yes, conscious of time. Yes, we'll keep you informed with upcoming webinars as well on other useful topics. I think the plan is to have those roughly every month or so, but there may be, emergency webinars perhaps when something comes at us out of the blue. So thank you everyone for attending today. It's really good of you. We'll keep you posted about additional ones, and I'm sure it's been useful for everybody. So for now, thank you very much. Catch you all another time. Cheerio.
Thank you. Bye.
Thanks, everyone. Thank you. Bye, everyone.
Thanks. Bye.